labor administration in India. Theories of employee welfare, you don't have to go much in detail about it, just the core idea. That is all that is required. This is a very simple topic, just for your understanding. And in this, we'll see what is the labor administration in India, what are the ministries, or what are the attached offices to the ministry, or what are the independent bodies, certain statutory bodies under the ministry, and how the labor is basically administered as a subject in India. Okay, this should be read from an exam perspective in such a way that there are certain bodies that you have to read, in which year the body is formed, what is the core objective of it, and there are certain institutions with big names. Okay, you have to learn what is the full forms of it. You don't know where, I mean, if a simple question like a expansion of a name comes, you shouldn't miss it, right? So those are the three important things that you focus while studying this part of lecture. Labor administration in India. It is basically a multi-tiered system. You have central government ministries, state government. State governments, they might have a ministry. Some state governments have a particular ministry with respect to Ministry of Labour Employment or Ministry of Labour and Training with different names. Some might not have, but every state government will have a department with respect to labour. Okay, and there are many attached offices, subordinate offices, and autonomous organizations like statutory bodies. EPFO. EPFO is a statutory body under EPF and MP Act, and specialized boards. Okay, all together combine and they administer the labor in India. If you look at the historical background of it, so how the labor are administered in the pre-independence era and how the labor are administered now. If you look at the time prior to 1947, there was a commission formed to study the labor, that is Royal Commission on Labour, which was formed in 1931. You have to remember the name, you have to also remember the year. We'll also read the recommendations given by this commission. I'm actually spoon feeding you. I don't have to tell you all the recommendations. You can just Google it, you will get it. But I'll give you a separate PPT. Maybe it takes 10 to 15 minutes of your time, but you don't have to go and search what else should I read, because everything I'm trying to cover in the class. So these provisions you have to read. Royal Commission on Labour, we'll have a class on this. And in future, you will also read about First National Labour Commission, Second National Labour Commission. These were also formed to study the labour and to suggest reforms in the labour sector. So we'll study those two commissions also in detail. What are the suggestions given by those commissions and what among those suggestions were taken and seriously implemented. Suppose now we have amalgamation of all the labour laws and we have come to finalize to 4 labour codes. That suggestion is given by Second National Labour Commission. It was formed back in 2002, but still now we implemented it 2020. So those recommendations are very important. And pre-independence time, this Royal Commission on Labour has given certain recommendations and certain rules, like how do we administer the labour sector in India. Based on this, the labour were administered in India before 1947. And if post-independence, if you look at it, we have got a constitution, we have got all the FRs, DPSPs that we studied earlier. Based on those principles, government has come up with certain laws and acts. We also discussed, right, while we were studying DPSPs. Based on all those laws, the new acts or schemes, the labour sector is administered. Labour is in concurrent list. This is also we have seen. And in 1954, Labour Investigation Committee has emphasized the need for enforcement. What is the approach that is again is this enforcement by the government? Which approach did we study yesterday? That is again is this enforcement of government. Good. Giri approach. Giri approach says government should not be like an enforcer. It should be like a mediator. It should act as a mediator. Its role has to be very minimal. So this is how, when a term comes, immediately your mind should function in such a way that where did I see this term before? Okay, 1954 is the time where Labour Investigation Committee was formed. It is the committee that emphasized the enforcement part. Okay, because Royal Commission on Labour gives suggestions, kind of guidelines, right? Follow it or not, but it has given this is how it has to be administered. That is why Labour Investigation Committee emphasized the enforcement. It is not that you just give the guidelines. You should make sure that they are enforced and they are being followed, like binding. 1966, this is very important year, Labour Bureau was formed to study everything related to labour and come up with certain factual information, statistics, and there are certain indices also this Labour Bureau gives, like CPI, Labour Workers, Consumer Price Index it gives. So we have to read everything about this Labour Bureau also. When is it formed? What are its functions? Take it as a homework. I'll also teach about Labour Bureau. Just study what is Labour Bureau, when is it formed, what are its functions, what kinds of report does it give. Okay, it gives certain reports, it gives certain indices. How does it study? I mean, what all factors does it take into consideration while coming up with reports? Because this is something very core to labour sector, right? So you have to study this in detail. So if you look at labour administrative machinery, at the central level we have Ministry of Labour and Employment. What are the responsibilities of this? All, basically everything under the umbrella. Industrial relations, to ensure social security, to ensure the training, welfare, dispute adjudication. All this are the functions of central ministry. At state level also we have labour departments. Maybe ministries also they might have, but labour departments are mandatory. They'll be headed by labour commissioners. We'll have labour commissioner at central level, and each state will also have labour commissioners. He's called CLC, Chief Labour Commissioner, Central Labour Commissioner, State Labour Commissioner, SLC. His responsibility would be basically if a central government implements a scheme regarding labour, at the state level he will ensure the registration for that particular scheme has been done, enrollment has been done, or enforcement, whether they are being enforced or not, or any dispute settlement. We have seen in state list that dispute settlement within the state, a provision we have read in the state list. So that is the responsibility of State Labour Commissioner. Now we have many attached and subordinate offices. You must know the full forms of all of this, because if there comes a matching, maybe there might come a matching regarding year of formation, the attached offices, or the attached offices, the function or role of it. They won't give you full form. Sometimes when they give the full form, it is easier to understand from the word itself what is the function of it. What does it do? What is the objective? But what if they don't give you the full form? Then it becomes difficult to guess. It becomes a guesswork. So DGET, Directorate General of Employment and Training. Okay. It was formed in the year 1946. Basically responsible for employment exchanges and occasional training. Okay. Next, as we saw in the previous slide, Labour Bureau formed in 1946. It is responsible to give certain statistics related to labour, CPI index, and certain publications. You have to, as a part of homework, you do a study on Labour Bureau. CLC, just write down the full forms, the year of formation, what is the main objective. Like a table, you just make a table, you maintain a book for shortcuts or a quick revision. Suppose while we are reading the Constitution, we just drew a small table regarding all the 4 amendments that are done, what are the things that have been done in the amendment. That's a table. If a question comes from that, you have to attempt it. Maintain a book for shortcuts, a small book, maybe a small table, this full form year, this full form year, or whatever we are reading. Just after the class, just try to write the entire class in shortcut. This will help you in revision. Okay. Labour Bureau, we studied. CLC is the Central Labour Commissioner. Office of CLC, we call it. It was formed in the year 1945. He is responsible for enforcement, conciliation and contract labor regulation. DGFASLI. See the full form of it and tell me. Directorate General of, see this is very difficult to guess also. So definitely you have to read it. Factory advisors, and this institute is basically responsible to provide technical advices, as in to the ministry or to the other offices. It gives, yes, it is Factory Advisory Services and Labour Institute. So this institute is basically an advisory kind of institute, either to other attached offices or to the ministry. It advises as on what rules to frame, how to ensure the working conditions are good. So they might ask which of the following attached offices is an advisory body. Simple question. Which of the following is an advisory body? DGFSLA. You cannot know from the names, right? Only if you study it, you can answer it. Technical advices it will give on safety, health and working conditions. These are attached and subordinate offices. Then we have autonomous organizations under the Ministry of Labour and Employment. EPFO. We'll read all of this in detail. ESIC. State Insurance Corporation. VVGNLI. Can you guess what it is? Ah, that's true. VV Giri. I told you to remember the personality. V.V. Giri National Labour Institute. This institute is basically for training and research in the labour relations. The previous body that we have seen, DGFSLI, that is an advisory body, technical advisors. This is a training and research institute. Okay, V.V. Giri National Labour Institute is a training and research institute. CBWD, Central Board for Workers Education. E is for education, not employment. If you don't know, you might think it's an employment, but it is Central Board for Workers Education. So you have to educate the workers, maybe regarding the safety provisions, how they have to work. They deal with so much of machinery, equipment. How do they ensure the safety, or to educate them about their rights, to educate them as in how to be more productive, how to demand their rights, or how to at the same time ensure the duties are fulfilled. It educates the labour sector. At state level also, these boards were being formed. Suppose there are construction workers. They are one of the most unorganized form, right? Mostly construction sector may you find this migrant labour, all of these people. So there will be board for workers education of these construction workers. They are mostly illiterate. They come from Bihar, UP, that states to Kerala, mostly Kerala, whoever construction worker you find, it might be from Bihar side or that northern part, northeastern or northern part, because they are cheap labor. They do not know there is a concept called minimum wages. So certain states will come up with a separate board for construction workers to educate them. Okay, this is one such institution and it is formed in 1958. So in states, state labor departments implement the central and state laws. Basically, states are responsible for the implementation because decentralized administration will be done, right? Labor commissioners, be it state or central level, they are called enforcement heads. Okay. Industrial relations machinery, there are other officers also and other officers also, like conciliation officers. There are labor courts, there are labor tribunals, welfare boards. As I already said, there are many welfare boards also for unorganized workers. Example, construction workers. If you look at the recent labor administration machinery, the codes, try to memorize the codes. Code on wages, industrial relations code, code on social security. These three are easy to remember. Last one, occupational safety, health and working conditions code. And digital initiatives, we'll read all of this. Shram Suvidha, E-Shram portal. And there is also something called as Indian Labour Conference. We'll read about this also. There are many conferences which are held in different periods of time. Especially in the early independence and just after independence, there are many Indian labour conferences that took place. What is the year that that particular conference has taken place? Who headed that conference? In that conference, what happened? I mean, what is the important thing that they have concluded in that conference? These are also very important. Even if I deal with it or not, study Indian labour conferences as a homework. So that is basically a tripartite body. Indian Labour Conference, whenever it happens, it is not like just employees come or employers come. It doesn't happen that way. People from all the three parties will be present in an Indian Labour Conference. That is, government will be present, employer side and employee side. All the three will have representation in Indian Labour Conference. This is blindly you can remember something. Mostly in all the committees or all the conferences that happen related to labour. In future also you read all the PPTs in different acts, different committees or different conferences are mandated to be performed. In all of this, they are tripartite bodies because we know IR is a tripartite relationship. So it is a tripartite conference. But what are the key challenges in labour administration in India especially is we are mostly unorganized sector. Okay. Most of our population is being concentrated in agriculture. That is also unorganized. We cannot ensure the benefits to them, right? We may come up with schemes, but how do you bring them into the legal structure? How do you ensure them? There are landlords who are, exploiting the farmers. Can you ensure that that is not done? No, that is at a very village level or rural level. How do you ensure that? So, bringing the unorganized sector into the organized framework is such a difficult task, and also with these times many new kinds of unorganized employment or different employee-employer relations, just like Swiggy, Zomato or this Uber, Ola, different employee-employer relation. No one knows who the employer is. That employer doesn't know who the employee is. So even with this new things come, that is also challenge to include them into the legislative part. And also many of the labor sector in India, most of them are illiterates. So how do we ensure that they are availing the rights or they are availing their wages, or if they are not entitled to them, are they literate enough to question it? That is also a major challenge in India. There are capacity constraints also. So for conducting these inspections or to ensure the enforcement is done, we need staff, right, to go and conduct the regular inspections. There is capacity constraint also. And so far, this multiplicity of laws, so many laws. If such case comes, we do not know according to what law we have to give a judgment. But now that the new codes have come up, that challenge is addressed, but still many states are yet to implement it. The codes have come up, but the states had to enforce it, right? That is not done completely yet. So these are the key challenges for labor administration. Unorganized, so unorganized that we do not know how to administer them. Many laws, according to what law do we have to administer them? That is also a challenge. And there is no awareness among the workers or the capacity constraints, like no proper staff or infrastructure or machinery to conduct the enforcement drives or inspections. So colonial to comprehensive institutional framework. From colonial times where there is nothing, where there is a big legal vacuum for labor administration, now that we have a comprehensive institutional framework. So such a progressive evolution that India has taken place. Centers, states, offices, autonomous bodies, welfare boards, we have all of this to do labor administration in India. We have also digital platforms, eShram portal. In eShram portal, all the employees get registered. All the employers also get registered. If an employer seriously wants someone to work for him, he'll see who is the capable person to work as a labor and he will appoint that person. But in practical scenario, not everybody is getting enrolled in it and no such, no such employer is taking an employee from that eShram portal, but that is what it is purported to be. Critical challenges, effective administration in unorganized sector. And one more, whenever I'm saying take it as a homework, remember you have to do it mandatorily. Take what is according to certain reports, you will have what is the percentage of unorganized sector or what is the percentage of unemployment, or you can take the census also, 2011 census also. So what is the unemployment in rural, unemployment urban? All this factual information, write it in one page and keep it. This might be helpful for your examination. Unemployment rates, recent figures, what are they? And recent figures of unorganized sector. What percentage of workers are in unorganized sector? In agriculture sector, how many people? Industrial service sector. So this is for the purpose of your examination. Just gather the factual information. There is nothing to teach you in that, right? Just gathering the information. Hope you are clear with this small topic. Sexual harassment at workplace and Vishaka guidelines. These guidelines are very important, not only from the exam point of view, even when you become an employee and you also go to a workplace, right? So it is mandatory to know what you should do, what you should not, what are your rights and what are your duties. So see, we have got independence in 1947, but we do not have any law or any specific act that prohibits the sexual harassment at workplace, unless and until this issue of sexual harassment has taken place in 1900s. Okay. So let us look at the background story of it a little. In 1992, you know, right, Rajasthan is known for its child marriages. Back then, very prominent, big number of child marriages used to take place in Rajasthan. Even now it is known for this. If a particular state comes into your mind, you should know what it is famous for and what it is notorious for. If you think of Haryana, all I get into my mind is sex ratio, bad sex ratio. Okay. So in Rajasthan, in a small village, a child marriage is being carried out. So Devi is a woman or a female named Banwari Devi. Okay. She's a social worker and she is appointed as a part of government's women development program. She is not some private or NGO social worker. She is appointed as a part of government's program for women development. Then after finding the child marriage is being taken or being carried in some part of village of Rajasthan, she went to stop the child marriage, or she went against the child marriage in that particular place. but the people of that place revolted against her or said few statements derogatory to her, and later the landlords, who are these powerful landlords, gang raped her. Okay, so she's doing her work, right? That is her duty. As a part of some program, she's appointed as a social worker, and she was supposed to do or prevent the child marriages and ensure the empowerment and make sure everybody is aware of all the acts and legislations. But as a part of her duty, if she does her duty, she's being gang raped. So then she filed a case. Later all the NGOs came together, and one of the NGO is Vishaka. So that's why the case is called Vishaka and others versus state of Rajasthan. The incident has took place in the year 1992, but the Supreme Court has taken up this case, or judgment has been given in 1997. Okay, Vishaka and others versus state of Rajasthan. All these NGOs together has filed a writ petition to Supreme Court under Article 32 regarding the sexual harassment of workplace. Now, what judgment that Supreme Court gave and what guidelines did it give? Basically, since we do not have any legislation to prevent the sexual harassment, first of all, Supreme Court has asked the center and state governments to come up with a legislation as early as possible to prohibit this act of sexual harassment. But until then, see, making a law in the parliament is not an easy task. It is time taking. So you cannot ensure, right? If it might take 2 years, 3 years, 10 years. 1997 it gave judgment. When did the POSH Act come? It came in 2013. So judiciary is aware of this. Judiciary asked the central and state government to frame laws, but it wouldn't do it immediately. That's why, to fill the legal vacuum between these years, judiciary has come up with certain guidelines. By hearing the term guideline, you might think it is a guideline, right? May follow it, may not follow it. By hearing the word, you may feel so. But the Vishaka guidelines given by Supreme Court are binding in nature and enforceable. It's not that it is up to them whether they'll follow it or not. They are binding and enforceable in nature. So, when a question or option comes like Vishaka guidelines are voluntary in nature, you might think guidelines, voluntary, they're matching. No, Vishaka guidelines are binding and enforceable in nature, because for this period of time, it has to fill the legal vacuum and make sure that no such acts take place in the future. So, Supreme Court has come up with certain guidelines, that is Vishaka guidelines. Now, we'll see what are the guidelines given by Supreme Court. This was already studied. Okay, there's one more point. We'll also study in this sexual harassment is against what articles of the Constitution. Okay, that is also important. So, this case is called Vishaka and others versus state of Rajasthan. The main triggering point is gang rape of the social worker in Rajasthan. Then NGOs filed a PIL, public interest litigation. In the previous case, we saw PUDR. There also it is a PIL. No legislation existed at that point in time. Now, Constitution articles, if you look at it, Article 14, right to equality, this is being threatened in this. Article 15, prohibition of discrimination on the grounds of religion, caste, creed, sex, everything. But since she is a woman, she is gang raped here. Okay, you are discriminating her. So, even this violates Article 15. Be specific with this article. Where trade unions is Article 19, Clause 1, Clause C, Subclause C. This is Article 19, Clause 1, Clause G. Right to practice any profession. If women are threatened by the acts of sexual harassment, will they be able to do or be able to be in a profession freely? No. That fear of intimidation or fear of being threatened will always be there in the minds. Hence, this article is being violated. Article 21, right to life and dignity. A woman has the right to live her life with dignity. When such acts takes place, she will be in a very depressed state. Her dignity is affected at a larger scale. So, this is also, so what are the articles that are being violated? 14, 15, 19, 1G and 21. And in the further classes, we'll read about ILO, International Labour Organization. And we'll also read about all the conventions given by ILO. And there are conventions called core conventions of ILO. There will be 8 conventions which are called core conventions. And we'll read whether India ratified those conventions or did not ratify from the exam point of view. So this is one such convention. This is not form of core convention as such. This is one of the conventions given by ILO, which is CEDAW. We call it in short form CEDAW. It is Convention on the Elimination of all forms of discrimination against women. Okay, this came up in 1979. India also had signed this convention. Despite signing this convention in 79, it did not come up with any law to prevent this act. So in Supreme Court, the Vishaka and others challenged all these provisions. They quoted that this particular act is violating 14, 15, 19 and 21. And they also quoted that India has signed this convention, but still hasn't come up with any particular legal measures. These are the things quoted by the NGO and Vishaka. So what is Supreme Court gave judgment in this cases? First of all, they quoted, right, these are the rights that are being violated. Supreme Court accepted with the fact. It also recognized that sexual harassment is the violation of those fundamental rights that are mentioned. It also noticed that there is a legal gap in this particular topic of sexual harassment. Ultimately laid down the guidelines called Vishaka guidelines, which has to be followed until the parliament made a new law. Until the parliament comes up with a new law, these guidelines are assumed to be binding and enforceable in nature. Now we look into Vishaka guidelines. First of all, any act, any guidelines, you should know definitions of certain important things. It defined what sexual harassment is in first place. Physical contact and advances, that is obviously a sexual harassment. Even demand or request for favors is also the same. Sexually colored remarks. If a sexist remark is being done, that is also comes under definition. Showing pornographic videos. Any unwelcome physical, verbal or non-verbal conduct. So they left it to the interpretation of judiciary. What might be unwelcoming of a good conduct? Okay, some cases might be too specific, right? They might not be in the act. Legally, see, you have certain ethical questions like some might be legally correct but morally wrong. Some might be morally right but legally wrong. So to that, certain things are left like this, unbecoming of good conduct. That might be depending on case to case, that might depend on the judicial interpretation of that particular case. So what comes under the definition is also important. Now this act also, so as a part of this act, what are the duties of employer? Duties of employer are both preventive in nature and curative in nature. Preventive in the sense, first of all, try to prevent the act in the first place. Make your workplace such a safety place so that the act do not take, the sexual harassment do not take place. Even if it takes place, what measures or how do you resolve it? The employer's duty is to come up with certain provisions, as in if the act takes place, how do you resolve the issue? Or another is bring awareness. Bring awareness to the female employees regarding their rights, that if it is violated, you can come to us or you can go to the courts. Female workers have to be made aware of this. Even rest of the employees also should be made aware of this, that key, if you commit this, you will be penalized, you will be punished. So to ensure all of this, it is a duty of employer. Take necessary steps to prevent the act, deter the acts of sexual harassment, provide a procedure. Even if the act occurs, how do you resolve it? How do you settle it? Or how do you prosecute the one who committed it? Okay. These are the preventive measures. How do they prevent? Prevention ke liye, what do they have to do? Notify and circulate. They'll have the notice board or somewhere. They should put it in the notice board that this is the penalty. If you do this, this will be your punishment. It has to be notified. Then circulate the prohibition of harassment. Everybody, they should ensure that everybody knows about this in the first place. Awareness and sensitization programs. They should be sensitized about this. Okay. Safe and healthy work environment. Incorporate the penalties in rules and standing orders. We'll read a certain act. See, we have this new codes, right? Industrial Relations Code. Under this code, we have 3 acts. One is Industrial Standing Orders Act. Okay. One is Trade Union Act. What is the other one? Industrial Disputes Act. These are the 3 acts under IR code. So one of ఇది ఇండస్ట్రియల్ స్టాండింగ్ ఆర్డర్స్ యాక్ట్, ఇది ఇండస్ట్రియల్ డిస్ప్యూట్స్ యాక్ట్, ఇది ట్రేడ్ యూనియన్ యాక్ట్. సో స్టాండింగ్ ఆర్డర్స్ అంటే ఏంటంటే ఒక ఎస్టాబ్లిష్మెంట్ ముందే వాళ్ళ ఎంప్లాయీస్కి కానీ వర్కర్స్కి కానీ ఒక స్టాండింగ్ ఆర్డర్స్ అంటే ఇప్పుడు ఇండస్ట్రీ ఏం చేయాలనుకుంటుందని ముందే చెప్తుంది. ఇవి రూల్స్ అండ్ రెగ్యులేషన్స్, ఎవ్రీథింగ్ క్లియర్గా స్పెసిఫై చేస్తుంది. సో ఇఫ్ ఈవెన్ ద ఇండస్ట్రీ వైలేట్స్ ఇట్, ద ఎంప్లాయర్ విల్ క్వశ్చన్ ఇట్. You told me that you would be following this particular rule or regulation, you violated it. Standing orders, it would give it in the first place. I'll provide you canteen, I'll provide you crutch, or I'll provide you this, that. Everything will be mentioned there and it will be fixed one. Even if a small change has to be taken place, it has to go to higher level government authorities. They have to approve it, only then they can change it. So this will be circulated. The standing orders, every one of the establishment will know. So this mandates, this law, this guidelines mandates it to be mentioned in its standing orders. If it is a private establishment, if it is a public employment, so public in government establishments or government employees, they'll have certain rules, like CSS rules, or state government employees, they will also have their rules. In their own rules, they have to mention about this sexual harassment. If it is private, they have to come up with standing orders. In the standing orders, they have to mention about the sexual harassment and incorporate the penalties. And this is very important. So the guidelines mandate the establishments to form a committee which is called ICC, Internal Complaints Committee. Okay, how this committee has to be formed? The head has to be a woman. Greater than 50% should be women members in that particular committee. One member should be NGO. Why we are including one third neutral party is, sometimes not the internal complaint, all the internal complaint committees may not be independent. They might be biased, right? Suppose if a male member who is an employer might threaten this head of the committee, okay, sometimes they are unbiased. That is the reason we need a third party member also in this. One member from NGO or external associations must act promptly and confidentially. It should be a time bound process. A woman is sexually harassed and you are taking years to complete the procedure of complaint. What will be the mental state of a woman then? What about her dignity? So it should be very promptly done and confidentially done. It shouldn't be spread like everybody knows about it. No, there should be certain procedure where you do it confidentially. Okay? Treated as inquiry authority. This is an inquiry authority to verify if the claim done by women is right or wrong, or how to gather the proofs against the person who committed the crime. All of this is the duty of ICC. From this, you might get a question. The composition of the committee. Women has to head it. More than 50% have to be women. One member from NGO. It acts as an inquiry committee. Disciplinary and remedial action. If any misconduct is being taken place, disciplinary proceedings have to be done against that person. Protection for victim and witness from victimization. See, a victim has complained, she should be protected, right? She shouldn't be intimidated that I gave this complaint, what if they come back to me and they do something to me? That fear shouldn't be there for the victim. So this is also the duty of the employer. They have to protect the victim and the other witnesses from victimization. And one more thing is annual reporting of complaints and actions taken. That establishment should maintain a register or a record of all the complaints that received in that particular year. What action has been taken place? What penalty is given to that particular person who committed the crime? Annual reports has to be maintained at any cost. If they do not maintain, the employer will be punished in the first place. Submission of complaints report to the government. Whether they are following the rules or not. Whether every establishment is having the ICC, internal complaint committee, they are having it or not. Or the composition is formed correctly or not. They should ensure that. Now one more question is, we said it is the employer's duty, right, to ensure that workplace is safe from all these acts. For third party harassed, like There are certain establishments that deal with external parties or the clients or the third parties, or there are certain cases where not only on site, it might be, let me tell you an example. There are some field jobs, right? This is the on site, this is establishment. Outside the establishment, if you went for purpose related to that work, even that case, who is responsible to take care? Yes, right? There are chances there also the women might be sexually harassed. Even then, the employer is responsible. Always try to remember the facts where you might get confused. If a question comes like guidelines are only for the people who are in the establishment, not for third party, or it is not the duty of employer to ensure third party harassments are not taken place. No, even if the third party harassment takes place, it is the duty of employer to regulate it or to take action against the third party. Employer responsible even if harassment by outsiders or clients, contractors, whoever the third party is, must provide support and preventive steps. There is another judgment called A.K. Chopra case. He says it's not just the physical contact. Beyond physical contact, even if moral and decency standards, it is against that also constitutes sexual harassment. Attempted molestation, not directly molested, even if attempted to do the molestation, that is also sufficient to take action against the person. Acts unbecoming of good conduct by seniors is also harassment. Superiors is also harassment. This also we discussed. Unbecoming of good conduct. Good conduct might be subjective. So unbecoming of that is also a sexual harassment. So later government has come up and enacted a legislation called POSH Act in 2013. Remember that it ensures compliance in both public and private sectors. Okay. So Vishaka guidelines are very much important because 1947 to 97 we do not have any law. Even 1997 to 2013 we do not have any law that prevents it. So these guidelines for all the 13 plus 3, 16 years it served as a limelight to prevent the cases. That is the reason Vishaka guidelines are very important. And they formed the basis or the foundation for forming POSH Act and ensured dignity of women at workplaces. They are legally binding. So you read this act. This is the first act that we read. There are many acts that we are going to read. So whenever you read an act, definitions, provisions, committees, composition of the committees, whether they are binding and enforceable or not, these are the probable parts where questions might come from, right? You have to focus it like that. Certain things are self-explanatory. Even if you don't try to remember those things, what things that you can't remember, only try to memorize those things. We are done with this. I guess no queries. While giving Vishaka guidelines, judiciary has said that these Vishaka guidelines will be existing until the center or state comes up with a law. So once POSH Act came into existence, now we rule it according to POSH Act. Okay. Now we will see the POSH Act and wind up the session. More or less, Vishaka guidelines and POSH Act is same. So you have to pick up the points where the difference is coming or where the new additions are done. Focus on that. That is enough. Both are more or less the same. The year. It is very important to remember the years, okay? Now that 1, 2 acts you can remember. But slowly it becomes 30, 40, 50. Then, chronology. What if they ask the chronology? They'll give Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, Equal Remuneration Act. Arrange them in chronology. But with continuous reading, మీకు ఆ యాక్ట్ ఇయర్తో పాటు గుర్తుండిపోతుంది అనమాట. అర్థమైందా? POSH Act 2013, బాండ్ లేబర్ యాక్ట్ ఇది, చైల్డ్ లేబర్ యాక్ట్ ఇది. సో అలాంగ్ విత్ ఇట్ వెన్ యూ రీడ్, రిమెంబర్ ఈజీగా అవుతుంది. లుక్ హౌ దే ఫ్రేమ్ ద నేమ్ ఆఫ్ ఇట్. I told you, right? Not only the shortcuts, you have to look at how the original name of the act was framed. The sexual harassment of women at workplace. Prevention, prohibition, redressal. Okay? The term. See, why are we focusing terms here is, I'm letting you know how to read this because when a question comes, even in UPSC CSC mains, write the provisions of POSH Act or anything. Okay, what are the safety provisions of women at workplaces in the constitution or in India? Just you remember this name. Prevention, prohibition and redressal. 3 pointers, side headings will be 1. First, prohibition measures. Second, preventive measures is one heading, where you describe with 1-2 lines. Third, redressal measures. You have got nice words to write in the mains examination. So this is how read little, present it more. Okay. With minimum knowledge, you have to be able to present it more. Background and need, this is already seen. What does it violate? 14, 15, 19 and 21. How did it lead to POSH Act? Banwari Dev case in 1992. Then Vishaka guidelines 97 and 2013 pe you have POSH Act. Read the objectives of the Act. Prevention, prohibition, redressal. The same which are there. Just the expansion of it. You can apply these techniques and tricks for mains answer writing, because while writing mains answer writing, you won't have time to think of the words, what to write. No, you should be spontaneous. Immediately your answer should flow while you're thinking, and writing has to go simultaneously. So these techniques would help you do that. Previously, Vishaka guidelines were applied to all the establishments, right? But now in this, look at it carefully. What did this POSH Act say? Applies to public and private. Wherever question might come, read it in that perspective whenever you're reading an act. Applies to public and private. Okay. With 10 plus employees. This is specific here. The organizations which are having greater than 10 employees. Doesn't mean ki if an organization is having less than 10 employees, women can be sexually harassed. No provision for that. No. Even if a women from an organization less than 10, even there it is applied. But here what they mean to say is, this POSH Act mandates to do certain things. Suppose publish certain things in standing orders, form certain committees, do this, do that. All those things have to be followed by establishments with greater than 10. This doesn't mean women at less than 10 are not protected. No. Because for an establishment as small as less than 10, doing all that would be redundant stuff, right? Lot of time waste, and also it's like they do not find it viable to do it. So that's why they are mandating it greater than 10. But women are protected even if it is an establishment having less than 10. Covers organized, unorganized, domestic. This is so hard to cover. Domestic workers also this act is covering. This might be a point where you get confused. How can they protect domestic workers? Right? They're working in a domestic environment, homely environment. How can they protect them? But this act has provisions to protect domestic workers also. Even unorganized. We always say unorganized is difficult to manage. It is difficult to bring them. But even here only we have got 3 pointers. Applied to public private, applied to greater than 10, applied to unorganized and organized, applied to domestic. 4 pointers for examination. Protects all of them, all women. They might be employees, they might be clients, students, interns, customers, visitors, all kind of people it protects. Workplace includes. There is an important definition of workplace. It is not just the office. It is outside the office premises also. Just imagine, even if it is a virtual space. Suppose a meeting is going on or a Zoom class is going on. Gmail conversations are going on. Even through that, if an act of sexual harassment takes place, that is also punishable. So this slide is full of things to remember where questions might come from. Employer provided transport. Even a transport is considered as workplace. Okay. The slide is clear. Public, private, greater than 10, organized, unorganized, domestic. This is what I'm saying. If you read about workplace, offices is inherent. That is what it is. But wait till you get confused, excuse me. Virtual space, transport. Even this is a definition of workplace here. So you remember these words or terms. The women who is being sexually harassed is called aggrieved women. And the person who committed the crime of sexual harassment is called respondent. I mean, against whom the complaint is made, that person is called respondent. We have specific names for it. We do not call women and this person who committed the crime. She is called aggrieved women. He is called respondent. Hostile environment test. We already discussed, right? It is a duty of the employer to maintain a proper healthy environment to avoid such acts. So circumstances where conduct creates a hostile environment, not a good environment. Intimidating, which is fearful. Humiliating work environment, interfering with the work performance. So any such bad environment that creates an impact on work performance. That is called hostile environment. These three definitions are cleared. Sexual harassment, we read, right? Definition: physical contact, sexist remarks, or showing pornography. All that is sexual harassment. Aggrieved women, respondent, and hostile environment. Now, in the previous Vishaka guidelines also, we have internal complaint committee. Here also we have internal complaint committee. There what did we read? Head is the women. Here he says heading is done by senior level women. But here there is one more thing. This is even less than 10 can form it. But it is mandatory for the establishment with greater than 10 employees. Okay. Presiding officer will be women. Basically what happens is women who is at senior most position. She will be presiding. One external member, NGO or legal. This is also common point from there. This is a new point from Vishaka guidelines. Read it what it is. 2 employees with social work or legal knowledge, because they will have better knowledge of what an act is, what the rights are, what to do if some act is violated. That is why we are including these people also for expertise purpose. Yes, outside. Social work or legal knowledge. Okay. This is for legal expertise. This is for humanitarian grounds to ensure unbiased opinion is given. 50% women also common, right? Powers, they have the power of civil court. Just like some statutory bodies and constitutional bodies will have the powers of civil court, no? This was also given the powers of civil court. This is something new. Local complaints committee. This we don't have in Vishaka guidelines. Since this law is applicable even for unorganized. Unorganized sector means they do not have a proper establishment. They do not have a common workplace. So where do the committee gets formed? How do they represent? So for those people, we have local complaints committee. Okay. And for domestic workers, where do they go? They don't have an employer to go to. They don't have an ICC to go to. They also go to LCC, which is local complaints committee. This was constituted, the district officer will be appointed, and this district officer will be constituting this LCC. For those who are less, so who all are not covered under ICC will be covered by LCC. So roughly less than 10, unorganized, domestic. For all these 3 classifications, we have LCC committee that is headed by a district officer. And where the complaint is itself against the employer, then they can't go to the establishment, right? They will be very fearful to go and represent their issue or problem. So even in this case, when the complaint is against the employer himself, also handle cases of domestic. Understood? Less than 10, unorganized, domestic, against the employer. The complaint is against the main principal employer, not against the co-worker. It is against the employer. Even then, they go to LCC. So the 2 committees we read. Complaint procedure. Here so many numbers to remember. I mean factual information, and you should remember it. Because simple question, you should not miss it. See, an incident has taken place. An act of sexual harassment has taken place. Within 3 months, suppose this is done in Jan 1st, for example, Jan, Feb, March. By March ending, the complaint has to be filed. Okay. If at any case, due to some reasons, the reasons should be justifiable in nature, not some random reasons which are not valid ones. Reasons should be proper and justifiable. Then this can extend up to 6 months. Filing incident అయినప్పటి నుంచి కంప్లైంట్ ఇన్సిడెంట్ అయ్యాక 3 నెలల్లో కంప్లైంట్ ఇవ్వాలి. ఒకవేళ ఏదైనా unknowing circumstances, suppose let us imagine she is so mentally depressed, she do not want to come out of her home, or she resigned everything, or she is so mentally unwell, ఆ కండిషన్ అనేది జస్టిఫైబుల్గా ఉంటే up to 6 months. She will be given time up to 6 months to come and file a complaint. This is one factual information that you remember. And if unable to file, so who can make a complaint is also an important thing. The person ఎవరైతే సెక్షువల్లీ హెరాస్ అయ్యారో తను ఫైల్ చేయొచ్చు, ఆర్ ఎవరెవరు ఫైల్ చేయొచ్చు అంటే లీగల్ హెయిర్, ఫ్రెండ్, co-worker, NGO, or any person with knowledge. అంటే ఆ ఇన్సిడెంట్ చూసిన ఆర్ విట్నెస్ చేసిన ఏ ఒక పర్సన్ అయినా అవ్వాలి, లీగల్ హెయిర్ అయినా అవ్వాలి, ఫ్రెండ్ ఆర్ co-worker ఆర్ NGO, వీళ్ళలో ఎవరైనా కంప్లైంట్ ఫైల్ చేయొచ్చు. సో ఇదొక పాయింట్ టు బి రిమెంబర్డ్. కన్సిలియేషన్ పాసిబుల్. ఓకే, sometimes if that person, aggrieved women, feels that the committee, ICC or LCC, it is not biased, it is unbiased, it might not give a good judgment. తనకి ఆ భయం ఉంది, వాళ్ళు కరెక్ట్గా ఇస్తారా లేదా, వాళ్ళు అండర్స్టాండ్ చేసుకుంటారా లేదా, దెన్ దే కాల్ ఫర్ అవుట్ సైడ్ థర్డ్ పార్టీ కన్సిలియేషన్. బయటకి ఎప్పుడు ఓన్లీ ఎట్ ద రిక్వెస్ట్ ఆఫ్ కంప్లైనెంట్, ఎవరైతే కంప్లైంట్ చేశారో తను రిక్వెస్ట్ చేస్తే దెన్ దే గో ఫర్ ఎక్స్టర్నల్ పార్టీ కన్సిలియేషన్ బిఫోర్ ఎంక్వైరీ. కానీ ఇది ఎంక్వైరీ అవ్వకముందే అవ్వాలి. అంత ప్రాసెస్ అయిపోయి జడ్జ్మెంట్ వచ్చాక నేను నౌ ఐ హ్యావ్ టు గో ఫర్ కన్సిలియేషన్, ఇది నాకు నచ్చలేదు కాదు. ఇఫ్ షీ డజంట్ వాంటెడ్ బిఫోర్ ఇట్ సెల్ఫ్ దే హ్యావ్ టు గో ఫర్ కన్సిలియేషన్. నో మానిటరీ సెటిల్మెంట్స్. కొన్నిసార్లు ఏమవుతుంది కన్సిలియేషన్లో, దే సే ఓకే ఇది జరిగిపోయింది, నీకు 1 lakh ఇస్తాము, ఫర్గెట్ దిస్. ఆర్ ఏదైనా సరే మానిటరీ సెటిల్మెంట్ షుడ్ నాట్ బి ద సొల్యూషన్. దిస్ ఈస్ లీగలీ అన్యాక్సెప్టబుల్ ఇన్ ద కేసెస్ ఆఫ్ సెక్షువల్లీ హెరాస్మెంట్. ఈ కన్సిలియేషన్కి వెళ్ళినప్పుడు కూడా మానిటరీ సెటిల్మెంట్ ఆర్ మానిటరీ కంపెన్సేషన్ అనేది నాట్ అలౌడ్. ఓకే, అండర్స్టూడ్ రైట్? సో 3 monthsలోగా కంప్లైంట్ చేయాలి, ఇఫ్ జస్టిఫైబుల్ 6 monthsలోగా చేయాలి. ఇప్పుడు వీళ్ళు కంప్లైంట్ చేశాక నౌ ద కమిటీ హ్యాస్ 90 days అనమాట టు డూ ద ఎంక్వైరీ, ప్రూఫ్స్ గ్యాదర్ చేయడానికి. కానీ ఇంతకీ ఆ కంప్లైంట్ కరెక్టా కాదా, దేర్ మైట్ బి ఫాల్స్ అక్యూజేషన్స్, రైట్? కోవర్కర్ ఒక మేల్ ఉన్నారు, తిన్నకి ఏదో ఇష్యూ ఉంది ఫీమేల్కి, షీ మైట్ రైజ్ అ ఫాల్స్ కంప్లైంట్. సో అది కూడా వాళ్ళు వెరిఫై చేయాలి కదా, అది ఫాల్స్ అక్విజిషన్ ఆర్ ట్రూ అక్విజిషన్ అనేది. సో కమిటీకి వచ్చాక కమిటీ 90 daysలో ఎంక్వైరీ కంప్లీట్ చేయాలి. కంప్లీట్ చేశాక 10 daysలో రిపోర్ట్ ఇవ్వాలి. ఆల్ దీస్ నెంబర్స్ హ్యావ్ టు బి రిమెంబర్డ్. సో 90 daysలో అయిపోవాలి, 10 daysలో రిపోర్ట్ పబ్లిష్ చేయాలి. రిపోర్ట్ పబ్లిష్ చేసిన 60 daysలో యాక్షన్ తీసుకోవాలి. సో చాలా ఫ్యాక్చువల్ నెంబర్స్ ఒకేసారి. 3 months, 6 months, 90, 10, 60. 90 daysలో రిపోర్ట్ చేయాలి, ఎంక్వైరీ చేయాలి, 10 daysలో రిపోర్ట్ పబ్లిష్ చేయాలి, రిపోర్ట్ పబ్లిష్ చేసిన 60 daysలో యాక్షన్ తీసుకోవాలి. సో డ్యూరింగ్ దిస్ పీరియడ్ ఆఫ్ టైమ్, ఇఫ్ దట్ విమెన్ వాంట్ సర్టన్ లీవ్, షీ కెన్ అవైల్ ఏ లీవ్ అప్ టు 3 months. Okay? If she wants transfer to somewhere else, you should be helping her with that. Okay? And other measures, whatever that makes her feel better, you should try to take other measures. So all these numbers, 3 months, 6 months, 90 days, 10 days, 60 days, and leave up to 3 months. All these are potential questions. Okay? Duties of employer, constitute ICC. ICC అసలు ఎస్టాబ్లిష్మెంట్ ఫామ్ అవ్వగానే గ్రేటర్ దాన్ 10 employees ఉంటే ఇట్స్ మ్యాండేటరీ టు ఫామ్ అ కమిటీ విత్ ఆల్ ద 50% గ్రేటర్ దాన్ విమెన్ అండ్ విమెన్ హెడ్. ఆర్గనైజ్ వర్క్షాప్స్, అవేర్నెస్ ప్రోగ్రామ్స్ కూడా కండక్ట్ చేయాలి. పెనాల్టీస్ అండ్ పాలసీస్ ఏంటి అనేది డిస్ప్లే చేయాలి వర్క్ ప్లేసెస్లో. ఓకే, వాట్ హ్యాపెన్స్ ఇస్ వీ హ్యావ్ సర్టెన్ ప్రొవిజన్స్ ఇన్ ఐపీసీ. ఐపీసీలో కూడా, ఇండియన్ పీనల్ కోడ్లో కూడా వీ హ్యావ్ ప్రొవిజన్స్ అగైన్స్ దిస్ సెక్షువల్ హెరాస్మెంట్. ఐ మీన్ స్పెసిఫిక్గా కొన్ని ఉంటాయి. సో ఒక్కసారి కంప్లైంట్ ఐసీసీకి కానీ ఎల్సీసీకి కానీ వెళ్ళాక, ఇఫ్ దే ఫీల్ దట్ ద సేమ్ యాక్ట్ ఈస్ వైలేటింగ్ సర్టెన్ ప్రొవిజన్స్ ఆఫ్ ఐపీసీ, వాళ్ళకి ఏం తెలియదు కదా, విమెన్ హూ కేమ్ టు కంప్లైంట్, షీ మే నో, మైట్ నాట్ నో. సో ఈ కమిటీ వాళ్ళు సజెస్ట్ చేయాలన్నమాట తనకి, దిస్ ఇస్ అగైన్స్ దిస్ ప్రొవిజన్స్ ఆఫ్ ఐపీసీ కూడా, సో గో అండ్ ఫైల్ అండ్ ఎఫ్ఐఆర్. సో యాక్షన్ విల్ బి టేకెన్ అగైన్స్ హిమ్ అండర్ ఐపీసీ కూడా అని దే హ్యావ్ టు సజెస్ట్ హర్. ఓకే, ఎఫ్ఐఆర్ ఫైల్ చేయమని సజెస్ట్ చేయాలి. అవును, ఇది ఎస్టాబ్లిష్మెంట్ లోపల. ఎల్సీసీ ఈజ్ నాట్ కన్స్టిట్యూట్ బై ఎస్టాబ్లిష్మెంట్ కదా, ఎవరికి ఎస్టాబ్లిష్మెంట్ లేవో వాళ్ళు కదా, లెస్ దాన్ 10 employees వాళ్ళు చేస్తారు. అన్ఆర్గనైజ్డ్ వాళ్ళు ఎవరి దగ్గరికి వెళ్తారు? డిస్ట్రిక్ట్ ఆఫీసర్ ఉంటాడు ఒకడు, అతని దగ్గరికి వెళ్ళాలి. ఓకేనా? ఎన్ష్యూర్ కాన్ఫిడెన్షియాలిటీ అండ్ నో రిటాలియేషన్. సో అది ఎంత ఎక్కువ ఉంది లేదు, అందుకే మనం ఐసీసీ కమిటీలో వీ హ్యావ్ లీగల్ ఎక్స్పర్టైజ్ ఉన్న ఇద్దరు ఉండాలి అని అన్నాం. ఎందుకు? ఒకవేళ ఆ ఎక్స్టెంట్ ఆఫ్ ద కేస్ బట్టి ఎఫ్ఐఆర్ ఫైల్ చేయాలా, అది ఐపీసీకి అండర్ ఎగెనెస్టా కాదా అని చూడ్డానికే కదా. దట్ ఈస్ వై వీ హ్యావ్ పీపుల్ ఫ్రమ్ లీగల్ బ్యాక్గ్రౌండ్ ఆల్సో ఇన్ ద కమిటీ. ఇంక్లూడ్ పాష్ కంప్లైంట్స్ ఇన్ యాన్యువల్ రిపోర్ట్. ఇది కూడా మనం విశాఖ గైడ్లైన్స్లో చదివాం. యాన్యువల్ రిపోర్ట్లో వాళ్ళకి పాష్ యాక్ట్ ఎంత కంప్లై అవుతున్నారు అనేది మెన్షన్ చేయాలి. పెనాలిటీస్, ఫైన్ అప్ టు 50K. ఐసీసీ ఒకవేళ ఫామ్ చేయకపోయినా, కంప్లైంట్స్ మీద యాక్షన్ తీసుకోకపోయినా యాన్యువల్ రిపోర్ట్ పబ్లిష్ చేయాలి. పబ్లిష్ చేయకపోయినా ఫైన్ 50,000 పే చేయాలి. రిపీటెడ్ వైలేషన్, ఒక సేమ్ ఎస్టాబ్లిష్మెంట్లో రిపీటెడ్గా సెక్షువల్ హెరాస్మెంట్ యాక్ట్స్ అవుతున్నాయి అనుకో, పెనాలిటీ వుడ్ బి డబల్డ్ అగైన్స్ దట్ పర్టికులర్ పర్సన్. ఒకవేళ సేమ్ ఎస్టాబ్లిష్మెంట్లో అవుతున్నట్లయితే విల్ క్యాన్సిల్ ద లైసెన్స్ ఆర్ రిజిస్ట్రేషన్. దట్ మీన్స్ హీఈస్ నాట్ బ్రింగింగ్ ద అవేర్నెస్ కదా ఎంప్లాయీస్లో. then we'll cancel, government has the right to cancel the license or registration of that particular establishment. False or malicious complaints. This is also a case as we previously discussed. Okavela, if a proof was found or it is established, then ICC or LCC may recommend action against complainant. Evaraithe complain chesaro vaalla meeda action teeskuntaru false ga claim chesinanduku. However, mere inability proof is not false complaining. వాళ్ళు ప్రూవ్ చెయ్యలేనంత మాత్రం అది ఫాల్స్ కంప్లైంట్ అవ్వదు. ఓకే, ఎపీల్ మెకానిజం ఉందా అంటే ఎస్ ఉంది, 90 daysలో. ఎవరికి? అప్పుడు చెప్పాను కదా, ఫస్ట్ ఏదైనా ఇంటర్నల్ బైపార్టేట్ లెవెల్లో సెటిల్ అవ్వకపోతే దెన్ వి గో ఫర్ ఎడ్యుడికేషన్, కోర్ట్స్కి వెళ్తుంది. లేబర్ కోర్ట్స్కి కానీ అప్రోప్రియేట్ ఏదైనా అథారిటీ ఏదైనా యాక్ట్ ప్రకారం ఎపీల్ వీళ్ళకి చేసుకోవాలి అని ఉంటే వాళ్ళకి వెళ్తుంది. సో దిస్ ఇస్ ద ఎపీల్ మెకానిజం. రిలేషన్ విత్ ఐపీసీ, సర్టన్ యాక్ట్స్ ఉండి ఫిజికల్ అసాల్ట్ కానీ స్టాకింగ్ కానీ అవన్నీ పనిషబుల్ అండర్ ఐపీసీ కూడా. అలాంటివి అయ్యాయి అంటే ఐసీసీ ఆర్ ఎల్సీసీ హ్యాస్ టు రికమెండ్ ఫైలింగ్ an FIR. These are other such cases. Vishaka, State of Rajasthan, we already read. Medha Kotwal versus Union of India, 2012. Monitoring complaints. Government has to do regular inspections. POSH Act కి కంప్లై అవుతున్నారా లేదా అని చూస్తూ ఉండాలి, కంప్లైంట్స్ వచ్చాక వెళ్ళి చూడడం కాదు అని చెప్పి ఆ పర్టికులర్ జడ్జ్మెంట్ చెప్పింది. నెక్స్ట్ సౌరభ్ కుమార్ వర్సెస్ క్యాగ్, 2008. వర్క్ ప్లేస్ ఇంక్లూడ్స్ ఆఫ్ సైట్ లొకేషన్స్. క్యాగ్లో బేసిక్గా ఆడిటర్స్ ఏఓస్ ఉంటారు కదా, వాళ్ళు మోస్ట్లీ దే జాబ్ ఇస్ ఫీల్డ్ జాబ్. డిఫరెంట్ ప్లేసెస్కి వెళ్ళి ఆడిట్ రిపోర్ట్స్ అన్నీ జనరేట్ చేయాలి. ఈ రిపోర్ట్లో ఈ జడ్జ్మెంట్లో అందుకే చెప్పారు వర్క్ ప్లేస్ ఇంక్లూడ్స్ ఆఫ్ సైట్ లొకేషన్స్ ఆర్ ట్రైనింగ్ లొకేషన్స్. సో విచ్ ఆఫ్ ద ఫాలోయింగ్ కమ్స్ అండర్ డెఫినేషన్ ఆఫ్ వర్క్ ప్లేస్ అని ఒక 5-6 ఆప్షన్స్ ఇస్తాడు మీకు. కిందన ఏబిసిడిఈ, ఏసీడిఈ, ఏడిఈ. సో అందులో ట్రైనింగ్ ఇన్స్టిట్యూషన్స్ ఉన్నా, ఆఫ్ సైట్ లొకేషన్స్ ఉన్నా, వర్చువల్ స్పేసెస్ ఉన్నా, ఎంప్లాయర్ ప్రొవైడెడ్ ట్రాన్స్పోర్ట్ ఉన్నా, యూ హ్యావ్ టు టిక్ ఆల్ ఆఫ్ దెమ్. స్ట్రెంగ్స్ ఏంటి? ఫైనల్గా ఇన్ని ఏళ్ళ తర్వాత, ఇండిపెండెన్స్ తర్వాత లీగల్ బ్యాకింగ్ వచ్చింది. కవర్స్ అండ్ ఇంపార్టెంట్ థింగ్ ఏంటి, అన్ఆర్గనైజ్ సెక్టర్ని కూడా కవర్ చేసింది మంచిగా, ఇన్ఫార్మల్ వర్కర్స్ని, డొమెస్టిక్ వర్కర్స్ని. అండ్ పర్ఫెక్ట్ టైం లిమిట్స్ పెట్టింది కదా, 3 monthsలో పెట్టాలి, 60 daysలో రిపోర్ట్ ఇవ్వాలి, 90 days, 10 days. సో వెరీ టైమ్ బౌండ్ ప్రాసెస్. మ్యాండేటరీ అవేర్నెస్ ప్రోగ్రామ్స్. రిపోర్ట్ పబ్లిష్ చేయమంది, రిపోర్ట్ పబ్లిష్ అయిపోయినా, అవేర్నెస్ ప్రోగ్రామ్స్ ఏం చేయకపోయినా, అవన్నీ చేయకపోయినా ఎంప్లాయర్స్ విల్ లెవై పెనాలిటీ ఆన్ ఎంప్లాయర్స్. క్రిటిసిజమ్స్ ఏంటంటే, నౌ దట్ we have seen it is not only women that are being harassed, there are cases of harassment against men, but we do not have that. Hopefully we might get it in future. So men unnaru, other sexual communities kuda unnaru, LGBTQ+, వాళ్ళకి కూడా ప్రొటెక్షన్ ఇలాంటిదే ఎన్షూర్ చేయాలి. అండర్ రిపోర్టింగ్ ఇస్ వెరీ మేజర్ ఇష్యూ. మనం లా తెచ్చాం, అవేర్నెస్ తెచ్చాం, కానీ వాళ్ళ బిహేవియర్లో చేంజ్ తేవడం అన్నిటికంటే కష్టం. సో వాళ్ళకి ఆ ఫియర్ పోగొట్టగలగాలి, ఆ స్టిగ్మా పోగొట్టగలగాలి. ఓకే, ఆ స్టిగ్మా ఆర్ ఫియర్ పెడితే బయట సొసైటీలో ఏమవుతుంది, అందరికీ తెలిస్తే ఏమవుతుంది అనే ఫియర్ ఉంటుంది విమెన్లో. సో అది రిమూవ్ చేయగలిగితేనే ప్రాపర్ రిపోర్టింగ్ ఆర్ ప్రాపర్ అప్లికేషన్ ఆఫ్ ద యాక్ట్ అనేది అవుతుంది, లేకపోతే కష్టం. ఐసీసీ సమ్టైమ్స్ ల్యాక్ ఇండిపెండెన్స్. చెప్పాం, అన్నిసార్లు ఇండిపెండెంట్గా ఉండక్కర్లేదు, బయాస్డ్ ఉండొచ్చు. వీక్ అన్ఆర్గనైజ్ సెక్టర్లో మనం ఎల్సీసీ ఫామ్ చేసాం, కానీ ఇంప్లిమెంటేషన్ ప్రకారం చూసుకుంటే స్టిల్ at a very lower rates, weak implementation. Ambiguity, false complaints handle చేయడం కష్టం అయిపోయింది చాలా. హౌ డు దే అరైవ్ ఎట్ అ ప్రూఫ్ లేనంత మాత్రాన్ని ఫాల్స్ కంప్లైంట్ కాదంటున్నాం, దానికి ఎగెయినెస్ట్గా ప్రూఫ్ ఎలా తెస్తాం? సో ఫాల్స్ కంప్లైంట్స్ వచ్చినవి డీల్ చేయడం కూడా ఇట్స్ అ బిగ్ ఛాలెంజ్ ఇన్ దిస్ పర్టికులర్ యాక్ట్. సో సజెషన్స్ ఏంటి? మేక్ దిస్ యాక్ట్ అ జెండర్ న్యూట్రల్, నాట్ ఓన్లీ ఎగెయినెస్ట్ విమెన్, విత్ ఎనీ అదర్ కమ్యూనిటీ, LGBTQ+ ఆర్ మెన్, అందరికీ ఇంక్లూడ్ అయ్యేలా చూడాలి. ట్రైనింగ్ అవేర్నెస్ ఇంకా ఎక్కువ పెంచాలి, సో దట్ అన్ఆర్గనైజ్డ్ ఆర్ ఇన్ఫార్మల్ వర్కర్స్ కూడా రైజ్ అయ్యే కంప్లైంట్స్ ఇఫ్ సచ్ కేసెస్ టేక్ ప్లేస్. ఇప్పుడు మన ఐసీసీ డెసిషన్ ఫైనల్ అంటున్నాం కదా, కానీ ఐసీసీ మీద కూడా ఓవర్ సైట్ ఉండాలి. ఐసీసీ డెసిషన్స్ ఎలా తీసుకుంటుంది, ఇండిపెండెంట్గా అన్బయాస్డ్గా తీసుకుంటుందా లేదా అనేది కూడా ఓవర్ సైట్ ఓవర్ ఐసీసీ డెసిషన్స్ ఉండాలి. స్ట్రిక్టర్ పెనాలిటీస్, ఉన్న పెనాలిటీస్ కంటే ఇంకా స్ట్రిక్టర్ పెనాలిటీస్ చేయాలి ఒకవేళ కంప్లై చేయకపోతే. ఇంటిగ్రేషన్ విత్ లేబర్ కోర్ట్స్లో కూడా ఇలాంటివి ఇంక్లూడ్ చేయాలి. ఫాల్స్ కంప్లైంట్స్ని ఎలా హ్యాండిల్ చేయాలి వాటి మీద కూడా దే షుడ్ కమ్ అప్ విత్ సమ్ క్లారిటీ. Just go through the summary. Done.